Well, thank you, Mr. Chairman. And, it just dawned on me that, Utah and I think Wyoming even has marginal skiing.
Oh. Appreciate it. Time has expired. We're now going to go.
I'd rather gavel.
Okay, we'll go.
I do appreciate it, Mr. Chairman, and thank the panel also for taking the time to be here. Mr. Porzak, I would like to be able to do some follow-up. How is the Forest Service's new use and occupancy permit water clause inconsistent with federal deference to state law on water issues in the West? And I believe the chief even spoke to Colorado water rights.
Yes, sir. I believe the consensus is that this is an end run around state water law because it's trying to gain federal control over water rights that it could not obtain under its Federal Reserve rights through the state water courts, and it's doing it as a permit term and condition.
Okay, when we're looking at your business, and I think you underscored a very important point during your comments, saying that all water owners should be concerned. In 3rd Congressional District, in fact, throughout the state of Colorado, water is what we absolutely need, particularly for the grazing end of it. But in your industry, does that become part of collateral, an ability to be able to expand?
It absolutely does. The water rights are a major source of collateral for the ski area loans that support their infrastructure, that support their improvements, and their general operations. And no lender is going to loan any money unless you can prove you have adequate water rights. And when they would look at this clause, they would see that, number one, the ski areas are divested of their ownership of the water right, and that there's no guarantee that the water will continue to be used for the ski area purposes. So this will have a major impact on the ability to obtain your financing.
Now, and I just want, so that it's very clear, people paid money for these water rights, didn't they?
Collectively, literally hundreds of millions of dollars. That's a very conservative number. I mean, some resorts have spent over, a number of millions of dollars just for one resort, and many of these arise off the permit area and are used to augment the use of water on the permit area.
Right. And under the proposed rule, the compensation for those hundreds of millions of dollars that were spent for water rights would be?
Zero.
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 So it's effectively a taking and infringing on Colorado water rights, Colorado water law.
No question.
Private property rights.
No question in my mind.
Great. What effect will this clause have on permit holders who received their permits after the 2004 clause was adopted, which did not require the relinquishment of these water rights?
Right. Basically, what it will do is force them to go back to water right clauses that existed prior to the 2004. Basically, you could have a new ski area owner who obtained the water right under the 2004 clause, thought those were the rules that were in effect, is going to be held to certain standards that existed many years before that. It could be decades before that they had no knowledge of and were not a party to.
So basically the rules are just becoming a moving target. We're creating more uncertainty. Is this impacting jobs?
Very definitely. When you impact the financing, you're impacting jobs. You're also impacting the balance sheet that the ski resort owners use to be able to obtain their financing. If you take away literally, tens of millions of dollars from their balance sheet, that will in fact impact their ability to obtain loans, and they'll have to cut back on the amount of money they get, and so that's going to mean loss of jobs because certain jobs are going to have to be cut.
Great, and I would like to go back. You mentioned this just briefly in testimony. It was a question that I directed to the chief in terms of having that comfort level that the water will be used for that directed beneficial use, be it ski industry or grazing. You don't feel it's there?
No, I don't. There's language, it's not a requirement, but it says that the water should primarily continue to be used for ski area operations without defining what those operations would be. But the operative word is primarily. You know, what does that mean? You can divest them of 49% of their water, which could have a major impact on ski area operations. Not just the snowmaking. I mean, that's the one everybody thinks about, but it's all the residential and domestic uses associated with the ski resort.
Okay, thank you, Mr. Chairman. I did neglect, I think even Nevada has one ski run? No?
Thank you, Mr. Tipton. When the government stops Colorado from making snow, maybe we can work out a plan to get the greatest snow on earth shipped over to you in some way, and you can continue going. Are there other questions for this panel? Mr. Tipton?
I do have just one more, Mr. Chairman. And Mr. Porzak, could you maybe give us a little bit of insight? I would be interested, going back to Powderhorn, or the powder company that's trying to develop a ski resort. How many jobs are potentially at risk, since they have the potential now maybe to not be able to have collateral?
The Powderhorn ski area is near Grand Junction, and it has not been open and not operated successfully for a number of years. A number of people have come in with both the expertise to manage the ski area and also the financial resources to really do improvements. The Forest Service, when they issued this new directive last week, basically gave the Powderhorn ski area no alternative but to agree to the new permit language. They asked that there be a reservation of rights so that if the language is subsequently changed through congressional action, court action, or by mutual agreement, that the new language would follow, and the Forest Service refused.
But just so clarification, so we're enforcing a rule that has not been approved?
That's correct. They're absolutely enforcing that upon the Powderhorn ski area, and you know, it is snowing now, and they want to open fairly soon. And so this would be the totality of the ski resort, so it would be every job associated with that ski area.
That's very interesting. I appreciate you bringing that to light. And just one more follow-up. It was my general understanding that off of the 2004 rule and part of this review process, it was to be able to create a little clarification. I'm gathering from you, is it your assumption that this proposed rule is now far exceeding what anybody was able to visualize and has some negative impacts?
Absolutely. There's very little relationship between the 2004 clause and the proposed new clause that the Forest Service has issued. I mean, just look at the original 2004 clause, which I had a hand in working out with the Forest Service, was literally 2 clauses. It was less than 1 page, and the new directive is 9 pages.
Well, I appreciate that. And Mr. Chairman, I hope share the same view. I find this very disturbing that we have a proposed rule that is in fact a rule that is already impacting jobs, already being enforced. And I deeply appreciate your willingness to include this in this hearing. I think it's incredibly important for my state and ultimately yours and the rest of our counterparts. Thank you.